we have the requirements. Now, I think what we've done in the past, and Randy and Andrew, you might be able to help us here, when it isn't possible to enter into an agreement or provide disclosures, we usually use language similar to as soon as practicable, you provide a copy. And we might just try to borrow that language from other rules. Randy and Andrew, does that sound right to you?
Yes, in the rule 1.5.1, where there's a fee division among lawyers who are in different law firms, the requirement that the client has consented in writing is either at the time the lawyers enter into the agreement to divide the fee, or, and the operative language is, as soon thereafter as reasonably practicable.
Mm-hmm.
And I think that's a concept that works for the attorney rules and might work here.
I think that it works here for two reasons. One is that we definitely want the information to be communicated as right at the first contact, communicated. And it only becomes important for the client to have a writing is when the client is hired or the paraprofessional is hired. So as soon as practical would be perhaps when they enter into a written contract, or when the first in-person meeting, or maybe mail it out to the client once they have their address, or email it or something like that. I like that language.
Another option is to bracket a comment, which I think would be helpful here to elucidate on the example where the first meeting is either in person or over the phone, that compliance with paragraph A of this rule in that circumstance can be achieved by, and just giving the example of sending a written disclosure either via email or hard copy when you get back to the office, or whatever appropriate language we want to draft. But I think that would be a helpful description for the circumstances that the rule is trying to achieve.
I'm just thinking, provide, whether or not this phrase is better positioned right after provide. Yeah, do you agree that maybe, here, let me show you how it would be. Maybe with a comma there, but I don't know if anyone has a strong opinion on that.
While you guys are mulling that over, let me mention one other thing that came to mind, and that is that in the rules of court, you find the multi-jurisdictional provisions. This allows out-of-state lawyers to practice in California under the limitations provided in the respective rules of court. One of them is Rule of Court 9.48, that is the cover for non-litigated attorneys temporarily practicing in California. And so you're a New York lawyer, you need to take a deposition in California. This rule of court covers you. And one of the requirements in paragraph B of 9.48 is that for an attorney to practice law under this rule, the attorney must, and subdivision 3 of paragraph B says, indicate on any website or other advertisement that is accessible in California, either that the attorney is not a licensee of the State Bar of California, or that the attorney is admitted to practice only in the states where the attorney is listed as admitted to practice. And so if I were a paraprofessional, I might have a website that includes the text of the disclosure. And if someone called me up on the phone, I think I would direct them to my website and say, as we're talking here, let me direct you to defantorumlaw.com. My first page has a link to a disclosure that, if you could look at it as we talk. And I don't know if that's going to replace the need to follow up with an actual written disclosure, but I think it's parallel to the concept in the rules of court that a consumer knows where someone's license is limited by being able to go to that person's website.
If I remember correctly, I had kind of added that to my version of the notice, to that this be posted off as under, website, social media accounts, any advertising. And then I wasn't aware of Rule of Court 9.48, which sort of says that that has to be done for these attorneys, but in the immigration consultant legislation, it requires at least a declaration that they're not an attorney to be posted anywhere they advertise or in any social media account they choose to use. At least that they're not an attorney. And I think the concern, Greg, it's just too long to put in on a website or something, right?
Well, I think there was some concern about putting all of these disclosures. I think the original suggestion was that not only appear on their website, appear on any brochure, advertising, printed materials, everything. And I think the concern was that was to require all of these disclosures on every one of those pieces of printed material was a little bit too long. But I think we also discussed the fact that there's another rule that requires certain disclosures on the website under the 7 series rules. And if you want, we can look at that quickly and see whether or not, but I understand what Randy is saying is proposing if we were to require these types of disclosures on a website, would
Actually,
they
Greg, what I was driving at was really a follow-up on Andrew's comment about a comment. And so if we use the as reasonably practical language, the comment could say, the attorney should do it as soon as possible. And one of the steps the attorney could take is if they had a website in compliance with the 7 series, at the first instance, they can direct them to their website that has relevant disclosures. And I think
that would require the 7 series rule to be in compliance with all the disclosures in this rule as well, in order to just discharge that obligation.
Yeah. And so it's really something that is more of a bridge as opposed to completely discharging it, unless you change the 7 series.
And I guess what the subcommittee has to decide is that good enough? Is that the level of public protection you want, that while they're on the phone, they can just say, hey, pull up my webpage right now. And I'm going to read these to you right now orally because I'm required to under my ethical rules. But I'm also required to provide you a copy of these disclosures, and you looking at them on this webpage satisfies that requirement.
I think there may be an issue with folks who don't have access or not functional.
Well, I think in that instance, you wouldn't have discharged your obligation. You need to provide them a printed version.
Right. So what about, again, that language as soon as practicable, or at least with the written contract if they're hired?
Well, so the language is being proposed, reasonably practicable. I think the disclosures in the written agreement would be too late, wouldn't it? Because we wanted these disclosures to be made before a consultation.
Right. But I'm assuming we are requiring that definitely the disclosures be made orally, like first thing. So we're assuming that's already been done, and we're only talking about just providing a copy of what has already been said, right?
Yes.
So I'm just saying, as soon as practical, if whether it's at, just put in the mail or refer them to the website, if they can use that, or at least at the signing of the contract.
Okay. I mean, I think that's a question for you guys that you need to decide if that's good enough. Just referring them to a web page.
Just no, because then there are going to be people who don't have computers and who don't, who are not even have that basic know-how. We see it every day. It's, not right now anyway.
I think we're all in agreement on this reasonably practicable concept and language, right? So the issue is just going to be if we want to include a comment and an example.
Mm-hmm.
Yeah.
And should you do the website? And my personal is with what Fariba said, sometimes they won't have access and they'll think that they can look it up later. I think it should be a written document to them, whether it's the first time they come in and meet in person or whether it's something that gets mailed or sent to the person. So they have it there in black and white.
I agree. I do think it's a separate question that Fariba might be raising, though, about whether there should be a separate requirement of either a posting on the wall or a posting on a website that also includes the information in 1.4.2. And if we do want to do that, if that goes here or if that goes in the 7 series.
Let's look at if it's okay, let's just look at the 7 series so we know what we're already requiring.
And Greg, to
yeah.
that point, do you remember when we pulled that out? Because I do remember it being in here, and I know that I think it was Amos, and I thought it was too much for like an advertisement, but we also thought that the website would be okay. But then I think we must have pulled it out because of the advertising one. So is that right?
Yes.
I was trying to piece it after that. Okay.
Yes, I think.
Yeah, I think we did all agree that on the website would be appropriate, though.
Yeah.
Okay, so I think C is what we're just, so this is the advertising.
Okay.
This is the advertising rule. C requires any communication, which would include a website. Their name, their contact information, at least one lawyer or licensed paraprofessional or law firm responsible for the content. A communication of communicate at least one licensed paraprofessional's license number, and include in the communication a clear and conspicuous statement that the licensed paraprofessional is not a lawyer. And this is what I was referring to. This does not include all the disclosures that are required under the notice to consumer. So to the extent you want to require them in any communication or have a separate provision under here that says on your website, you need to have all of the requirements that all the disclosures that are required under rule 1.4.2, we would need to add that in.
I think it's fair to ask that if they choose to reach out and sort of recruit customers, clients by a website, I think any other type of advertisements that they'd be really clear that they're not a lawyer and that they provide those disclosures. I think it's reasonable to require that.
On the website only, not on every advertising communication.
I'm just going, by, okay, two separate things here. The declaration that or the statement they're not a lawyer versus the entire notice. So I just reviewed the immigration consultant registration, again, just a notice piece. And they do say that declaration that they're not a lawyer has to be on any advertisement that they choose to use, whether it's a website, brochures.
We are doing that, I think. In C, that's on the screen.
Yeah.
We are requiring that statement. That's C3.
Right.
That it needs to be a clear and conspicuous statement. So we're requiring that. I think
so that's one thing. The notice, I think, can be, because it's longer, then it could be on a website where there's just a link to it or something like that, or even print element. It's just a website.
Right. So, could we just add a D here and say any website advertisement, something like that, has to have the disclosure that's listed in rule 1.4.2, and just make it really easy.
Yes, I just wanted to also draw our attention back to, this is the solicitation of clients rule. Says every written, recorded, or electronic communication soliciting professional employment from any person needs to include the following: the word advertisement, right? And also include their name, contact information, license number, a clear and conspicuous statement that you're not a lawyer, and if the advertisement is subject to this subdivision is in the language other than English, the statements required in the subdivision shall be in the same language as the advertisement. So back to your comment, Kim, you are suggesting that we add a D here.
It's just a suggestion to kind of cover some of the comments and everything about the website, so that, any website posting shall include the disclosures required in 1.4.2A. Or maybe just all of 1.4.2.
Any website posting.
Okay, I'm not using good language, but that,
No, I know. I'm just trying to think of a better way of, because it's really their firm's website, right? Or
Maybe you could say any website advertising the paraprofessional
Services.
services.
Are we going to run into problems with that because they're permitted to advertise with other websites and they're going to be restricted by that website's
but doesn't that fall
requirements
on,
for their advertisements? Like I imagine if they want to advertise on, I don't know, CBS Market Watch, something, they're not going to necessarily be able to put all those disclosures into their
Right.
ad.
How about just old-fashioned mail? Why can't we just require them to mail a copy to the client unless the client refuses to provide their address because they're just calling and asking for information? Again, we're requiring oral statement containing all the provisions in the notice, and a copy by mail if the client is willing to provide an address or the potential client.
I think if the subcommittee is willing to allow paraprofessionals to discharge that obligation to provide written disclosures by referring somebody to their website and ensuring that they have access to that web page and are able to obtain it, that they have discharged their obligation under that rule. So then rather than mandating that paraprofessionals include this web page on their website, they're encouraged to do so because this is a very quick and easy way for them to provide those written disclosures.
And
So I think that's right from the perspective of the paraprofessional discharging its obligations under 1.4.2. But I think the other perspective is consumers who may be looking at websites to try to decide if they want to reach out or decide where they should go for legal services. And so I think the open question is, do we want that information on the website without the requirement that they call or have some sort of consultation first before they get that information?
Would it be helpful to look at the notice to consumer again to see what disclosures we're requiring?
Sure.
Okay, so we already know that under 7.2, they're required to disclose that they are not a lawyer and they have to provide their name and contact information, license numbers. So additionally, under the notice to consumer, they have to state that they have a limited, essentially a license to provide limited services, what their area of practice is, that they cannot provide all the services that a lawyer can provide, that they may need to hire a lawyer if their legal services that they need exceed the scope of their license, that there may be alternative choices available to them. And we have a list of some of those, non-exclusive list, a general description of their fee structure and billing methods, and whether or not they have professional liability insurance. So that's what we've required under the notice to consumer. The question is, do we want to require them to include all this on their firm's website? And maybe it's as easy as saying that, the law firm's website, the website of the law firm or something, to make it clear that it's a website that they control rather than one that they may be advertising on.
I think that is a big clarification because I think you're right, Greg. We don't want to make it every website.
I mean, if they have a website, how onerous is it to, require that they include that? I mean,
I don't think, most of it doesn't seem that onerous. They may have to update the fee structure and billing methods information and whether or not they have professional liability insurance to make sure that's up to date.
Mhm.
But other than that, the rest of these disclosures are, once written, I don't think they're going to change unless they obtain another paraprofessional license or something like that.
Right. And as we were going through this, I think really some people like the understanding and justification that this is really explaining what it means. What's the relevance that they're not a lawyer? What does that really mean in plain English, and how would it affect somebody? So I'd be in favor of it you know, if we think it would not be too burdensome. And again, I think your limitation that you're pointing out, Greg, is right. We don't want this on every advertisement, but if they have a website that's under their control that they're advertising on, I think that that may make sense.
Okay, so let me make a note here. So 7.2, I think the suggestion was to add D. And we can wordsmith this later, but the firm's website. And then, and we'll make this more fulsome and rule-like. But and then I think we would want to have a comment to the extent everyone's in agreement that you can discharge the obligation to provide written disclosures under the notice to consumer by directing them to the website. You might want to include that in a comment that's directs the attention to the requirement to include all these disclosures under Rule 7.2D, and to say that you can discharge this obligation by directing them to the website, so long as you make you make reasonable efforts to ensure that the prospective clients has access to that web page.
Right.
Something along those lines.
I'm just looking at the practical application of this. If the first consultation is by email or live chat, let's say, so it's in writing anyway, and the paraprofessional gets the live chat, and in their first response to the live chat, it has to be this, right? So they probably have just copy and paste. They have met the requirement to provide a written copy of the disclosure, yeah? And email too.
Well, they may have, that's where this rule kind of gets a little squirrely for you, because they're also required to provide it orally. So if they're in a live chat, query whether they've discharged their obligation to provide it orally.
Right. We just got live chat, so we're using it a lot, and I'm assuming we're going to see that out there, right?
But maybe we should move on, because I think we have the language for the rule, and this is for the comment, and I'm not even sure we fully agree, because I think we've now said a couple of inconsistent things about whether that would satisfy the obligation. So maybe we just try the comments separately.
Okay.
There were a couple other comments from the full working group on 1.4.2 from Judge Yu and Judge Rubin in particular. I don't know if it would be easy to incorporate Judge Yu's comment or not. I think it was mainly about 1.4.2A4 and wanting it clear that those services might be available in the preferred language. I'm not sure exactly how to incorporate that, or if it's actually true in all cases.
So I'm sorry, A4, is that what we're looking at?
A4, I think Judge Yu wanted to make the disclosure include language access issues. In other words, those alternate services may be in the preferred language.
Mm-hmm.
I don't know what people think about that.
Wouldn't A, because you're giving it to them in the preferred language, wouldn't it cover A4?
Yeah, it would. I think
talking,
Judge Yu's point is that like self-help and legal services organizations may have language access available, right? So
Legal services.
how about alternative choices in their preferred language? There may be other alternative choices in their preferred language available for the prospective client to consider.
Does that make sense to me?
That doesn't make sense. Yeah, because in whose in their preferred language.
No, I was talking about the first line.
No, I know,
Oh.
but I'm not sure choices is something that could be provided in preferred languages. I think it would have to be the services that are provided.
Right.
So there may be other alternative.
What about what I just put up there? I
So
just added in their preferred language to the self-help and the family law facilitators office.
services.
I like that, but it is limited to those two choices.
And
Yeah,
do
I don't
we
know
know
how
who the,
Go ahead, Kim.
sorry, I was just gonna say, do we know who the there is really pertaining to when we look at it, the way it's written in there?
Could we maybe put that on hold and move on to the next suggestion? Because I'm not sure if it's necessary.
I'm not sure that that one is necessary. I'm
Okay.
struggling with that one because they're already getting all the information in their language, and so they'll know that there's self-help centers, and
Okay,
hopefully
okay
those
with
centers provide language.
I'm okay with that. Judge Rubin also had some comments on this one, although the truth is I couldn't fully understand. I thought it might have been in the ordering of what's listed here, or that not all of these services may be available in all cases or something like that, but I think that's already,
I think what he was
captured by
referring
this
to was this provision here. And he was saying that some free legal services from local legal aid organizations are not income specific. I mean, you don't have to qualify based on income. One example, I think, was from the healthcare collectives that help people with medical billing issues. I don't think that's income specific in terms of what the services that you may be able to obtain. So I think what he was essentially saying is it should say something along the lines, potentially free legal services from a local legal aid organization, but the prospective client may need to qualify for those services.
Right, and qualification could be issue qualification or income qualification. So I think
Right.
it's fair to leave that in there, because even if there's no income qualification, there's still issue qualification,
Oh,
right?
that's a good point, Pariba. I think that's a good reason to keep it the way it is, actually.
yeah, me too.
I also had from him that he thought that was too much, but I don't know what my note, I'm looking at my notes now, and I'm not sure if he was saying there's like too many things there. Does anybody else have that written down?
I don't.
Mine's also confused because at the end of the day, I thought it might be a ordering of what's in there that he was concerned about. So I'm fine with leaving it. The other comment I noted is IRAs in 1.4.23, replacing may with shall, but we did discuss at the full working group. I actually think may is more appropriate. And Greg, I think you talked about that at the meeting too.
Yeah, I've reflected on that afterwards. I think I understand a little bit better what Ira was saying, which is, if it exceeds their license, they have to refer them out. But I don't know if we want to create a disciplinary standard where in every instance a paraprofessional has to make a referral, because sometimes they may not be able to do that. I mean, they may not have anyone to refer them to readily at their fingertips, but they can say, this exceeds my license, I can't provide you these services, and you probably need to find a lawyer. And
yeah, but my concern is not everyone can afford a lawyer. So
that's true too, but that's true too. And it doesn't, in that instance, if you know that the person can't afford a lawyer, you can't provide them services, you don't want to subject them to discipline just because they're not making their referral.
But why can we change number 3 to just say that the paraprofessional will just look at the paraprofessional and what the paraprofessional has to do, which is sub out of the case, stop representation, rather than where the client is going to go. The client may self-represent, through the self-help center, family facilitator themselves, may hire an attorney, ask a friend for help, So I think we're focusing, number 3 is focus. Are we looking at number 3 or am I dreaming? We're looking at number 3, right?
Yes, we're looking at number 3.
Okay.
This is only a disclosure requirement. This is not what they need to do if that actually happens. Like if it comes to pass that suddenly your client is asking for legal services that are beyond the scope of your
Mhm,
license.
yeah.
There's another rule that deals with that. And that's the one that I think during the full working group meeting I referred to, where they need to stop providing services and refer them out to either another licensed paraprofessional who can provide those services or a lawyer.
Right, I understand that. I'm just saying the disclosure piece should be focused on what the paraprofessional has to do versus what the client has to do.
So I disagree, and I think we should stay with this language. Again, the purpose of the disclosure is to inform the client of whether or not they want to hire this paraprofessional. And it's an important fact for them to know. Maybe the most important fact for them to know is that they may need to both hire this paraprofessional and then hire a lawyer. They might not be covered with legal services.
But I think that's actually conveys the wrong message, or at least an incomplete message, that they may have to represent themselves or hire a lawyer or could go to a legal services agency. It's just we're giving them one option here, that they may need to hire a lawyer. That's what I have a problem with. They may have to sub the paraprofessional out, something else.
I mean, if you would like it to be more inclusive, I think that's fine. So it could say something like, the prospective client may need to hire a lawyer or represent themselves if legal services. I think, again, I don't know that more is better, but I think that would be accurate.
And it actually, based on our prior conversations, we felt that I think that these other disclosures really flowed from this first statement, which
That's
is
true.
I am not a lawyer. And
Yeah.
you may need to hire a lawyer
That's right.
Yeah.
I think that's right. So I do suggest we leave this. And again, to circle back to Ira's comment, I don't know that it should be a shall instead of a may.
How about will?
But-
May need, will
but
need.
my problem with that is there may be, I can easily imagine instances in which you're unable to refer them out to another lawyer. And so to say that they will, and when there may be a situation in which they can't,
What do you
sets
mean by
them
that?
up. What's that?
What do you mean by that? I don't understand. This is just a disclosure saying, basically, hey, you need to let me go and do something else, right? Hire a lawyer, represent yourself. So what are you talking about?
Well, if the paraprofessional suddenly realizes their client needs legal services in an area of law that they are completely unfamiliar with,
Yeah,
they have no contacts in the legal community that handles these kinds of matters. They probably know that there are lawyers out there that can do that, but they don't feel like they're in a position to provide them a lawyer. Or as Amos, I think, raised, they already know their client can't afford a lawyer. They are now in a position where they have disclosed to their client that they will make a referral, but they can't make a referral. So it's a trap for the unwary, I think.
I don't think this talks
of.
of, okay, I'm sorry to interrupt, go ahead.
That's okay.
And to me, the way this whole thing reads are these things are a disclosure, and it does kind of feed off that number one. So because I am not an attorney, if you turn it into I'm giving this to the person and you put it into like the first person, right? I'm giving this to the person. So I'm not an attorney. I can't provide all legal services, and you may have to hire an attorney if I can't provide those services. So that's how I'm reading it, to where, to me, the shall and may, it reads okay the way it is in here. That's kind of just thinking it through how you're providing it in a written format.
Right, and I don't think it imposes a duty to refer, if I'm hearing you correct. And I was thinking, how about switching 2 and 3? If it flows off of 1.
You got cut off there, Fariba. Can you say that
Oh,
again?
how about switching 2 and 3 if it flows better off of 1? I'm not a lawyer. You may need to hire a lawyer. And by the way, there's services available in through these other sources.
So the reason I think 2 belongs where it does is 2 is the reason why they may need to hire a lawyer. It's because they have a limited license and that the services may go beyond that limited license. So I think it flows this way, explaining 1.
And I think, Greg, your explanation that you gave at the meeting, I think it stands.
Okay. Should we move on? Because we probably have we haven't gotten a few divisions.
We
I
do
don't
spend a
know.
lot of
Let's
time
do it.
on-
I'm confused, but forget. I can easily forget it.
I'm sorry, I missed that. What's that?
No, don't worry. Move on, move on.
Okay. Okay, so I also have a note here on 1.4. Oh, that's 3. Something about adding LDAs to A4. Written consent, A4. A statement that identifies the area of law. I don't know what that note from Leah actually means.
I actually think it might be the other one, 1.4.2.
Oh, A4. Oh, okay. She had 0.3.
Yeah,
Okay.
I saw it, but I
Before.
think it might be this one because
to
there
add,
could be, you could also get it from an LDA. I think
I
that's
see.
what
Oh,
the
and
public comment said.
that's where I said, wait a minute, I thought we were gonna have UP get rid of the LDAs. I would not agree with that.
I
Okay.
mean,
Okay. All right. Let's move to 1.5.1 then. Does anyone have anything on 1.4.3, the informed consent? We still have this outstanding issue with available contact information.
Can I ask if Fariba if you've done more thinking on this? Because I know in the housing subcommittee call, you maybe reconsidered your position on this a bit. So just interested. So the issue is whether with available contact information should be included. Now, again, this is when they already know what the issue is. They are providing, more detailed information about alternative choices. And should they be required to specifically provide contact information for legal aid programs if they,
So my position is to not require it as a default position, leave it to each committee to determine how onerous will be for that area of law in every county. So for example, there may be some counties where, in general, there may be some issues where there are not a lot of resources, but family law, for example, there's lots of resources. And it'll be too onerous to have a complete list and have to update that list. And I just don't want to impose any requirements that are subject to discipline where we're just asking too much is too much.
Okay, so sorry for the digression. I thought there might be, but I think we're still where we were.
Okay. And when we get to how we want to present these, I think that's probably something you're going to want to vote on, right? Amos?
I guess,
You have to think about
as
that.
opposed to just, we can talk about how to present them.
Yeah.
I think mostly all of our recommendations, it's the three of us have the same recommendation. I think that might be the only point. And then of course, 1.5.1 and 5.4, we probably need alternate choices.
Right. Okay. So 1.5.1, we did receive, let's see, from Steve, a suggested addition to the requirement with when licensed paraprofessionals and lawyers who are not in the same firm share fees. And let me see if I can pull up his suggestion. I think I have it here. Hold on one sec. Okay. He is suggesting that we add B5. No fee shall be divided between a licensed paraprofessional and a lawyer under this rule. Well, I think there's some error here, but may relate to any services performed which fall outside the scope of the licensed paraprofessional's license, including but not limited to any services rendered in their capacity as a paralegal.
So my sense is that shows that maybe the rule isn't clear, because I think that would already be captured by incorporation of the model rule limitation, right?
I think so too. I mean, this.
I thought we discussed this. Didn't we discuss this already?
I don't think we discussed his suggested change because I think this is something that he proposed later. Originally he proposed this as a comment. If we added this as a comment, but then when he circulated this last week, he added it into the black letter of the rule.
So am I reading, I don't know if it's written this way, but I think from Steve's comments and everything he said, I think he does not want a paraprofessional to be able to receive fees from a firm that are for services that they wouldn't be able to perform. Is that correct?
Yeah, the example that he used, and this is why I had me scratching my head, because this is already permissible. The example that he used was somebody who is a licensed paralegal who operates as an independent contractor for an immigration law firm. And they offer their paralegal services to the immigration law firm. And they enter into a fee sharing agreement such that, again, a fee sharing agreement, it means that the fee for legal services are provided to the client on one invoice. That's the ABA model rule comment. We don't have that version in our comments and that query whether we should, but so his concern was they're not licensed to provide legal services in immigration space. And this could be a backdoor to allowing fee sharing for these paralegals who also happen to be licensed paraprofessionals. I guess my response to that is, one, there's nothing to prevent them from doing that now. I mean, if you're working as a subcontractor, you can provide paralegal services to an immigration law firm, and the fees that you charge the law firm will be included on an invoice that's sent to a client, and they may even say, you know, paralegal services. His question is whether or not paralegal services qualify as legal services under the rule. But to the extent that they're providing services that, what he's saying, exceeds the scope of their license, suggests to me, one, they're engaging in the practice of law and they're not doing so under the direct supervision of a lawyer. So, I mean, because paralegals, even though they can work as subcontractors, they still need to be supervised by a lawyer if they're doing the types of things that we might consider to be legal services, like drafting legal documents or conducting legal research, which are allowed to do under the supervision of a lawyer. So I'm a little confused by his example. And I think it's beyond the scope of the subject matter of this particular rule, which is a licensed paraprofessional providing services as a licensed paraprofessional, which means they can provide legal services without supervision from an attorney. And that in those situations are sharing fees. So that's my take on that.
Oh, go ahead, Kim.
Oh, sorry. I was just going to say that, you know, I think, again, what I've heard a lot too is, like, if I owned, you know, there was this law firm of attorneys and they owned 51% and the paralegals owned 49%, right? I mean, not our paraprofessionals owned 49%, and there was a case, right? And things got split for the money. He doesn't think any of that money should go to the paraprofessionals. Is that correct? I just want to make sure I'm on.
I think that's really covered under Rule 5.4, and that's a separate issue. It's related in some ways because I think Steve is operating under the assumption that paraprofessionals should not obtain fees for any services that they're not licensed to provide.
Okay.
But the example that he provided actually doesn't fit with
Right. Okay.
Because this is somebody who's also licensed as a paralegal, and they are licensed to provide paralegal services. And there's nothing to prevent them from doing so under the supervision of a lawyer if it's, you know, in the immigration space.
So I agree, Kim. I think that is maybe the bigger issue, and we'll get to that in 5.4. For this one, I don't think we need this language. I do think what it raises for me, Greg, is maybe some confusion about B2. And again, that is different than what the normal rule is for lawyers. So again, there might need to be some explanation of what B2 requires.
Mm-hmm.
And I think it would address the concern that they're really only allowed to be compensated for the things that they're licensed to do.
Right. I have, as you see in the comment here, I have added comment that the paraprofessional can only assume joint responsibility for a matter, which is only permissible when they're sharing with another licensed paraprofessional, if the entire matter is within their scope of licensure. I think we can also say that there should be some comment that deals with what you're talking about, Amos, which is
Right,
proportion of
and-
services means you're only receiving fees for the services you're providing.
Right. And again, some training on that, but probably a comment would be helpful too, because I do think this is a concern of a lot of people, and it's different than the attorney rules where peer referrals are allowed.
Okay. Okay. All right. Anything else with the fee sharing? Trying to see if we had any other comments.
While we're here, can we drop the word each from B2?
Oh, yeah.
Each
thank you.
paraprofessional should be the paraprofessional, I think. Hopefully that's unobjectionable.
Yeah, I agree.
I think it's just,
Oh, yeah.
I think we just copied and pasted from the lawyer rule. I think it's just an unintentional remedy.
And Andrew, please I didn't actually incorporate your changes yet because I wanted the subcommittee to pass
Sure,
on them. But
of
as we
course.
go along, please interject like that because we're trying to look at, we're tracking so many different sets of comments from people at this point. Okay, anything else that we need to focus on with the fee sharing before we move on?
I'll just say for the alternative version, I think we have a couple choices, but I think the alternative version would just simply be no fee sharing, right? Because remember, we had talked about a couple alternatives because we could track the attorney rules, which I think would be even more controversial. So I think as an alternative to 1.5.1, we should just prohibit fee sharing.
And that would essentially track what Washington does.
Amos, just to clarify, would you, any fee sharing at all, or just the fee sharing between paraprofessionals and lawyers? Would you retain A?
That's a very good question. I don't know what people think. I of course, I'm in favor of the way it is now, but I'm just trying to anticipate what the right alternative would be. So of course, I would be in favor of paraprofessionals sharing fees. Again, I think what we really want to encourage on a policy matter is attorneys and paraprofessionals getting together and figuring out a way to work together. So I feel less strongly about A. Greg, do you mind going up to A? So
Sure.
or even
I know time is limited. I don't know that we need to focus on it. I was just curious if you had thoughts or if anyone recalled if specific concerns were raised about A. My recollection was most of the concern was on B, but A may have gendered more concern than I recall.
I believe Washington even bars fee sharing among triple LTs, but I can go back and confirm that. So what that means essentially is in Washington, if you're both providing representation, you're sending two sets of invoices to your clients.
Right. And that's certainly possible. And that would happen without B. You know, be like, you're going to hire a lawyer independently, you're going to hire me independently. We're going to work together, and you're going to have to pay us two separate ways. And that's a possibility.
And you don't have these.
What are the risks of doing that? Fee sharing in this way?
So I think the three of us agree that we would like to allow this.
Yeah.
I haven't heard a lot, except that it's very, very controversial. And I think the main issue is it's not necessary to stand up this program. And it's a big change from current practice, which limits. Only attorneys are able to do this, and attorneys can't share their fees with non-attorneys. And so you know, and a lot of this will be considered by the other working group. And it's a slippery slope. Once you start allowing one, why don't you allow the other? So those are the main arguments I've heard about that. But at the end of the day, I think the three of us don't fully understand the concerns or don't fully agree with them, but they're real. And I actually think we might be in the minority. So my proposal would be to just, as the alternative, is just prohibit fee sharing and fee splitting.
And an argument can be, I think, can be made that it's to follow the Washington rule may be less protective of the public. Because again, I mean, one of the important provision is the total fee charge does not increase by virtue of the fact that you're sharing the fee. So there may be duplicative work that a client is being charged for, like researching particular legal issues or what have you, that would not be prevented under that Washington rule because they're not allowed to share fees and continue.
Absolutely. And again, I think as a public policy matter, we want to encourage working together, paraprofessionals working with lawyers, and have, you know, again, in the UD context, have a paraprofessional do the answer, do some discovery, and then if it goes to trial, and have that all worked out in advance, you know, rather than all of a sudden needing to hire an attorney. You know, but again, I think we need to tee it up for the full working group.
Okay.
Right. How can we convince them?
I'll make my pitch, but I'm 50-50 right now about batting maybe a little worse than that.
In the long run, though, it kind of makes sense to encourage that working together, because then we have the right people doing the right things. I think that is, Amos, what you've said. I mean, that's the true issue here.
And what Greg is saying, because you certainly can do it without fee sharing, but you may be increasing the cost.
Right.
Do you want to move to 5.4?
Can we go anywhere else?
If we could look, I don't know if we got anything on the written agreement that we needed to address. Oh, Andrew, you did have a change here, which was, I think, a good one. I think this, there was a reference
on
here.
D, yeah.
Yeah, that's wrong. So that needs to come out. I think
It
it was
doesn't
because
change
there
the
was,
substance, yeah. If anyone on the working group needs an explanation.
the reason I think that was in there was because under 1.16 at the termination of representation, you need to provide the client file. And
You did,
I think
yeah.
I think this was just a sort of a vestigial reference to that where and the remainder was taken out.
I agree.
Okay. All right. Well, let's move to 5.4 because I'm sure that'll take the balance of our time anyway. Let's see. Hope I'm not making people dizzy by doing this.
And Kim, 5.4, I think, is where it's the ownership of a law firm where there's attorneys and paraprofessionals working together, and we're proposing minority interest. And this is, I think, the main concern is, okay, well, the law firm is going to generate profits potentially over all sorts of clients and practices that are outside the scope of the license. And then if you own a 10% or a 49% share, part of your profits are going to be outside the practice area. And this is the quote unquote lightning rod. So again, I think we're all on the same page, but I think we need an alternative that is no, you can't do this.
And Steve, I
Alternative.
think Steve provided that alternative. One comment I want to address quickly because I think it may be something that we can dispatch with quickly. Jeannie Harrison had made a point with regards to this provision that we should include or indirect supervisory authority. And the concept of indirect supervisory authority, I think, is already in one of the other the supervision rules. But I wanted to see what the what the subcommittee thought of that suggestion.
So Greg, I actually thought it was a good recommendation.
So exactly what is the concern that the paraprofessional is told to work with someone who is really being supervised by an attorney and train them on something? What's the actual concern here?
I think the concern is that you may have, an organizational chart for your firm where no lawyers are reporting to a paraprofessional, but in actual practice, the paraprofessional is indirectly supervising or overseeing the work of the lawyer. You can imagine this happening, especially when you have junior lawyers working on a matter where you have a more seasoned paraprofessional who may feel it's incumbent upon them to mentor this person in some way or direct their professional judgment in some way. And even though they're not technically considered their direct supervisor, they are indirectly supervising them in a way.
Did you mention that indirect supervision is included or defined somewhere else? Because I have a worry it might be too ambiguous. The concept makes sense to me. I also
oh, sorry, Amos, go ahead.
I was just going to add, I also think it raises ambiguities in the context where a paraprofessional is a part owner. So whether they own 1%, 10%, or 49%, any owner might be considered an indirect, depending on what that means, an indirect supervisor.
I've seen this on our side when we've had individuals like an RDO, which is a registered dispensing optician with optometrists. And I've seen the word indirect in some of our law to make sure that you know that it's not just that direct supervision, it's also that indirect. So from my perspective, I thought it was a good catch and a good thing to add, as long as it's clear, like Amos was saying. But I think we should put it in there, but I don't know where it is otherwise, so Greg.
Do you have, we do use direct supervisory as a concept in 5.1. Randy and Andrew, do you have any comments on this about whether or not it would be too ambiguous to include indirect supervisory?
One approach would be for the paraprofessional rule to delete the word direct. So it is just a prohibition against having supervisory authority, period. And I think that avoids the, pregnant question of, well, what is the difference between direct or indirect? And in the attorney rules, 5.1 B uses direct supervisory authority because it's holding the supervisor to disciplinary consequences. And so it's trying to narrow the scope of your disciplinary exposure by saying exactly what Amos was alluding to. If you're just an owner of a multi-state law firm, but you don't have direct supervisory authority over the person who messed up, then you're not going to be responsible as a manager for that person. But if you do have the direct supervisory authority, then you should be held liable. So it works there. I don't know if it works here.
Yeah, I like the suggestion of deleting direct or indirect.
You could
Just,
yeah. I was going to say, you could also have perhaps in a comment whether or not a paraprofessional has supervisory authority over a lawyer will be based on all the facts and circumstances of the situation or something along those lines. Which is all true, but it just provides.
I think that's right, although it shouldn't just be ownership of the firm, right? Because then that's circular. We're allowing minority ownership.
Oh, I'm sorry. I must have misspoken then. I meant whether or not they have supervisory authority is based on the facts and circumstances.
Right. Yeah, this works for me.
Okay. All right, let's get to the harder issue. So actually, Steve did provide, let's slide down to his suggestion. He is essentially taking the position, which is he has many times already, there should be no ownership interest if a licensed paraprofessional is practicing in the same law firm with a lawyer. So he is suggesting that we say any licensed paraprofessional, well, I guess that would be possesses if he makes it singular, any ownership interest or exercises controlling managerial authority in the firm. So this could be an alternative that we offer, which still allows them to practice in the same firm. They just can't have an ownership interest.
So I like that as an alternative. We might be able to clean up this language a bit to make it clear.
Mm-hmm.
But I do think that's the alternative we want to offer, which is no ownership.
And I think that that would address whether or not they're fee sharing. There's still the possibility in this situation for the paraprofessional to fall within the exceptions under 5.4 for profit sharing, because they're an employee of, essentially an employee of the firm. They can participate in, a profit sharing arrangement or retirement plan, and that would not be considered fee sharing within the same firm.
And I think several of the commenters that raised the concern about ownership actually relied on those other available options to still have a beneficial financial arrangement. You don't need to have ownership to do that. So at least my sense is an alternative just dealing with here, no ownership would be sufficient, I think.
And on this one, there is a lot of, again, I think I talked about this before, but there is a lot of other professions that do this with individuals who can practice partial scope of practice. I mean, we have medical corporations that can be 49% nurses, and so they have doctors doing things, and if they're part of that corporation, they get part of the money. So I mean, and that's just one out of, it continues to grow in the corporation code. I don't know, they're probably up to close to 20 different types of professional corporations where others can make money together. So I know it's different than the way the state bar's done it for always, but there is some history on other licensed professionals.
You may want to include in your, whatever the memo that goes out to the full working group, references to those other.
Okay, because I do know there was a comment, and I can't remember if it was from Steve or who, somebody said like a nurse practitioner won't be able to receive what a physician, if a physician does something that's beyond the scope of a nurse practitioner, but they do. I mean, that's part of a medical corporation if they're a part owner in that. So I actually called and made sure, I'm like, am I crazy in this? But I called and they're like, no, yeah, if they're part of it, they're 49%. So.
And is it correct that it has to be a licensed professional like a nurse? It couldn't be a because I think part of the concern, I might be reading between the lines. I think one of the commenters said it specifically, but they're concerned about the slippery slope. If you let paraprofessionals share, why not Amazon or Walmart legal services, right?
Yeah, it's definitely just professionals. And it's very specific as to who can be an owner. It's listed in the law. It's this person, this person, this person. So no lay people.
I think that is all I had from Steve or the notes that Leah provided from our meeting that we needed to cover. Andrew, I know we have other things from you. Should we go through those next?
I just had one other nit that we didn't get to, and then I had I guess a bigger question about whether the term information in 1.6 should be modified. That might engender a larger conversation.
Okay, let's grab your nit real quick.
My nit is in 1.4.1. It says all other matters. I think the term other is a remnant and just should be deleted because there isn't any more, there aren't two or more matters. It's just, should be all matters.
Why was this deleted entirely then? Shall promptly communicate unless perfect client all the amounts termed.
Oh, it looks like it's already taken out.
Yeah,
Well, I think it should be in all matters.
Okay.
Well, maybe it's written okay.
I'm trying to remember
I apologize.
how we got here where the whole thing was deleted. I think it was based on someone's suggestion, but
yeah, I guess it's okay. Of any written offer made to the client. So I think that's fine.
Yeah. I think
Fewer words. Okay, I didn't see that.
Implied. Okay. And then your bigger issue is with which one?
So 1.6.
Oh, right.
A.
Confidential information.
Right now is written, and maybe this is something that has to be addressed at the back end, but just for something to think about, as written, it says a licensed paraprofessional shall not reveal information
Right.
relating to the representation. And my impression was that was too broad, and maybe we haven't had a conversation about it. Obviously, the issue is one you've already discussed, that duty of confidentiality for lawyers originates in the statute, but I thought it should be modified.
And to the extent that the legislature acts to create a new confidentiality provision under the Business and Profession Code, we probably would just change this back to the way it's written for attorneys with the reference to the appropriate section in the Business and Profession Code. The reason it was written this way for the lawyers rule, information protected by, because we wanted to incorporate all the case law interpreting that language from the 19th century, the inviolate secrets and what have you. So this seemed like the most efficient way to do that. So we may revisit this after at the tail end of the process as well. Okay.
Yeah, I think this was a good catch.
Yeah.
And then Randy had a comment on 1.8.10, where there are statutory prohibitions on lawyers that still exist, notwithstanding the fact that the rule of professional conduct is generally considered a prospective ban on sexual relations with a client. The statute also prohibits a lawyer even attempting but failing to enter such a relationship through coercion, intimidation, or undue influence. And so Randy had a catch under A3, and whether we want to add in seeking to enter into sexual relations with a client. Just a slight wording change.
Mm-hmm. So I'm sorry. So
So A3.
A3.
So employ coercion, intimidation, or undue influence in seeking to enter into, as opposed to in entering into. So let's say you try but fail.
Oh yeah.
Threatening,
Mm-hmm.
that should not be condoned.
Which makes this clearer than the rule for lawyers, because lawyers have to refer to both this rule and the provisions under the State Bar Act, which makes it somewhat more confusing, but shouldn't be that confusing because this conduct is clearly beyond the pale. So, okay.
And then it might be, again, not right for discussion, but Brady had mentioned a couple statutory obligations for lawyers that obviously don't apply to paraprofessionals. And so we just for illustrative purposes added something to misconduct, but I think that conversation can wait.
Yeah, and
I
so
think we are planning on going through the Brady memo and his recommendations at some point, right? So the question is,
we haven't had a chance to do that yet. So I think he
Yeah.
was going to hopefully do that soon.
the question is, I think the proposal is to have these rules of professional conduct ready for a vote at the next meeting. So that might be something we have to move up so we can go through. I don't anticipate too many disagreements. I thought most of them were somewhat straightforward, but it seems like we need to put that on the agenda.
And I don't think there's any harm actually in putting in those two provisions in 8.4, at least as placeholders until we know what the legislature plans on doing.
I had them in brackets, which might not mean anything to anyone on this working group. It's a drafting technique that the Rules Revision Commission uses or did use in terms of presenting options or alternatives or things to tee up for discussion. And so staff just added a G and H, which captured two of the statutory prohibitions, which is threatening to report the immigration status of a suspected immigrant who's going to testify as a witness or a party in a matter, or to advocate for the overthrow of the government. through violence or other unconstitutional means, which are statutory prohibitions that apply to lawyers today.
Okay.
I had saw those in Brady's memo. I agree. I think those should be in there.
Okay. So
Now, one thing we did touch upon earlier was that where you decide to codify it could have some difference. And, Amos mentioned it specifically that the State Bar Act can have remedies, statutory codification can have remedies that the rules can't. And these two, I believe, refer to disbarment. And typically for an insular rule of professional conduct violation, disbarment might not necessarily be on the table unless there is aggravating circumstances or priors or something of that sort. And maybe this suggests that way downstream at some point, in order for this paraprofessional discipline system to be completely, worked up, the attorney disciplinary standards has standards for attorney sanctions that were revised not long ago. And so ultimately there might have to be standards for paraprofessional sanctions in order to really clarify some of these issues in terms of penalty phase. But yeah, if you put them in the rules of professional conduct, you're capturing in, and that there's absolute Supreme Court buy-in because the court will have to approve them. If they are creatures of statute, then they stand apart the same way they are in the lawyer regulation. They are standards, and if they're worded as cause for disbarment, then that's what they are. Brady mentioned one other one, I think, at one point, which was the duty of a lawyer to keep their licensee records up to date. So if they change their address, change their phone number, change their email contact, and they don't update the State Bar within 30 days, then that's under 6068. That's a violation. And I think he did mention that one in passing, but I wasn't actually sure if that should go into 8.4. So we did use that as one of the illustrations. But these two, if we want to have them as misconduct standards for paraprofessionals, and they're not going to be codified in statute, I think they fit well in 8.4. Others might not.
Randy, can I ask you a question about that sanctions for attorneys? And Kim, this might be a question for you from the discipline committee, but is it possible, if this isn't sort of automatically done, to have some sort of rule or suggestion that the paraprofessional board or whoever's doing the disciplinary decisions can and maybe should look to similar discipline that is done for attorneys with similar conduct? Is that something that we need to sort of include in the rules if that's what we want to happen?
So I guess we would have to look at that, right, Greg? We've kind of talked about the rules of conduct, right? But I know that, like, for us, we have like the disciplinary guidelines that say if you violate this, then these are your options. Here's your maximum and your minimum. We put those into regulation, but I don't think that the State Bar has that, right?
well, they do. He was alluding to the standards, and the standards essentially set forth what could be considered aggravating circumstances, mitigating circumstances, and then standards based on the type of misconduct the person is engaged in. So for instance, misappropriation will lead to suspension or disbarment based on the circumstances. Also, there's a standard that encapsulates the concept of progressive discipline under these standards. And the way the court treats that is that when the State Bar makes a recommendation, if it's a suspension or disbarment, makes a recommendation to the court that the attorney should be suspended or disbarred. And they need to, the way they structure their decisions, there's a whole culpability section where we deal with the facts and what the standards are. And then there's a level of discipline portion of the decision from the State Bar Court that discusses how the attorney's misconduct lines up with our standards, with their prior discipline history. It goes through any mitigating or aggravating circumstances that they feel that either the attorney has provided sufficient evidence for the mitigating circumstances, or OCTC has provided sufficient evidence to establish aggravating circumstances and what weight each of those circumstances get. And then compared, and then, well, there's a concept under the standards that they need to apply they need to essentially apply the sternest discipline to whatever the misconduct was. So if the worst infraction violation was misappropriation, the standard for misappropriation needs to apply. And then if they are somehow deviating or suggesting more severe discipline or less severe discipline, they need to explain why to the court, so that the court they provide great weight to the standards, and but they also can choose to, because our review is de novo on all of those things, we can decide whether or not we agree with the discipline. In most cases we do, but there have been instances where we've returned cases to the state bar if we feel that they've been either too lenient or too severe, and it happens on occasion. But I hope that answers your question. They do have standards to follow, but they're not mandatory standards.
Okay. Yeah, that same thing, kind of like others. And we actually haven't gotten to that, right, Greg? So we've just, I know we're going to start meeting again, but we haven't gotten to the standards for paraprofessionals yet.
No.
And I guess my question was just following up on Randy's point. Maybe that's something that can just be incorporated, or maybe there needs to be a whole new, but it sounds like that's going to be in the discipline subcommittee, not this subcommittee, which is great.
Mm-hmm.
Well, and you're right. I mean, if they're very similar, because our rules are very similar. I mean, we've taken them from the attorneys, and so it should be pretty easy to look at them and see if they're just very similar, right?
Yeah.
I know we do. Yeah.
Well, we have 5 minutes left. Are there any other issues that you would like to address, either based on the feedback you received or any other issues with the rules before we start talking about, in the last 5 minutes, how we want to approach presenting these to the working group? One more. Well, in terms of presenting to the working group, I mean, and kind of building on our experience with the Rules Revision Commission, I think one of the more efficient ways of doing this is, and I think I've mentioned this before, is really to have separate votes on each of the rules where we are imposing a heightened standard on paraprofessionals as compared to what the standard applies to lawyers. For the ones that we're essentially taking the lawyer rule and just applying it as is to paraprofessionals, I think those can be bundled together potentially, unless, and we can provide the working group members, notice, appropriate notice. These are the ones that we're bundling together. Notify staff if you would like to take any one of these rules out for separate consideration. So just so that we can get the bulk of what I think is about 73 rules that we have right now, 72 or 73 rules, the bulk of them that we can get through on sort of a consensus vote. And then we can just focus in on these rules like 5.4, 1.5.1, the informed consent and notice to consumer rules, and have separate discussions and votes on each of those. Does that make sense to the subcommittee members?
I agree with that. Yeah.
Yeah.
Sure.
And
Okay.
Greg, you guys haven't received any other comments from anyone other than Steve? Like anybody other changing? Because I know you sent it out. Okay.
I'll defer to State Bar staff because I know that sometimes people send you guys comments directly and not to me. So.
Yeah, I know Linda has circulated all the comments that she's gotten so far, so I'm not aware, and I was checking throughout the week because I know she's on vacation. I haven't received anything.
I think that's where we stand. Okay, so I think what we'll do then is staff will get together and start grouping these rules together and figure out, even within certain rules, we may want to take separate votes on those alternative provisions. I think we identified a couple already in this meeting. If there are any others that you think need to be provided as alternative, let us know. But I think we should start making a list of the ones that should go on the consensus vote grouping, and then the ones that we want to separate out and have separate votes on.
Does it make sense, Greg, even on the consent ones to still go rule by rule? I mean, sorry, consider how they should be grouped, because it might be, we don't want to take too many together at once on completely different topics, but
We could do it by chapter.
that's what I mean, chapter, right?
Yeah, so we could do the one chapter, which is the bulk of most of the rules, actually.
Yeah.
We could go through the one chapter and then two chapter and then pull out, then return to the ones that we have excluded. So it'd be all in chapter 1 with the exclusion of
Right.
1.4.1, 1.4.2.
That would probably be my suggestion, because it's logical to me and it's sort of how the rules are set up.
Mhm.
They sort of group together nicer that way. But if you have a different preference,
No, I think that's fine.
I just have a question on the ones that Brady has sent to us. Are there anything that we need to get done to put into the rules, like the ones that Andrew just brought up, other than those two that we need to make sure are in there before they go to vote?
so if I understand, you're talking about specifically the idea of using the miscellaneous, the 8.4 misconduct, and putting in other statutes or potential statutory changes in Brady's memo here. And we just haven't gone through that list. So I suspect I suspect the proposal to add them here makes a lot of sense for several of those rules.
And we have done that also with regards to runners and cappers, right? So we did
Okay.
included that in the solicitation rule as well.
So there's none that we're missing from what Brady has put forward that we need in these rules of conduct, right? Other than those.
Not that I'm aware of at this point. No.
But my sense of that is when we do go through Brady's memo, we probably will want to add some of them here
Okay.
that are probably not going to be controversial, that they should be prohibitions,
Mhm.
subject to at least discipline, if not more.
And how many alternative provisions do we have? They're not that many. We have consensus on more than we don't, right?
Well, I think the proposal was to also offer alternatives even where you do have consensus, just because it seemed like the working group may
Mhm.
not go with the
Like the fee sharing?
recommendation.
Right.
Like fee sharing, and also 5.4, the ownership of the firm.
Yeah.
Correct.
Okay.
But there's also Amos's change to the written, is it the written agreement where the contact information?
Yeah.
So that's one.
If I can't convince the two of you, I don't know how much hope I have. I agree with
So that's one, but are there others where just the three of us don't agree?
And none are coming to mind right now.
Yeah, that's what, I just don't think there are many. There's just one. And hey, I'm hearing Amos backing up. Come on, Amos, get it.
There may be, we may identify some other rules where we feel that we still need a full working group vote on.
Yeah,
Because
full discussion.
we're imposing a standard higher than than the standard that's imposed on lawyers. And so we'll make a list of those, but that's not alternatives. That's just separate votes that we suggest that you take.
We have another meeting, right? We have a meeting every week.
Yeah, so we have a meeting next week.
And so will we get your list and then we'll have a discussion
Yes,
on
we
the
will
progression
endeavor to
of the
have that
vote and all that, right?
Yeah.
All right.
All right, so shall we stop there?
Yeah, can I ask a quick question? It's off topic in the last few seconds. It's really, I think, for Kim, again, with the discipline. I think Leah's note said, let's talk about what else is on the table. And I think separate from the rules of professional conduct, we had an earlier meeting, the regulation and the discipline about fraud and resources for fraud and what we wanted to do. So I think that's still an open item for us to discuss. I don't know if we want to have another joint meeting or how we want to deal with that.
Yeah, we can see. I can't remember when our next meeting is. It's coming up though. We just scheduled one. So I will look at that, Amos, and then see if maybe we can even split that and bring you guys in for maybe half of our meeting to talk about that.
Okay, great.
I'll talk to Leah about it.
Okay. And there was some, I think both you and I had comments on the governance structure. I had recommended that it be sent to our committee, the regulation committee. I don't know that our chair agreed, but that's something that I think maybe we want to make some proposals on as a committee.
I would agree with you on that.
Yeah, and one other thing I had in my notes about retention of records. I don't know if we've covered that or if there's a specific rule, but I think there needs to be. Is there any rule currently about how long records need to be maintained or what records need to be maintained?
By attorneys, you mean?
Well, that would apply to
Yeah.
paraprofessionals.
I don't believe that's covered in the rules of professional conduct for attorneys.
What do you mean by records?
Yeah. There are
The
certain-
client records after their
In the file?
services are terminated?
Papers
Is
and
that what you-
property that belongs to the client?
Well, I
Well,
mean,
I think
usually
that's more about-
I'm thinking about if a dispute or something arises. So certainly the client file itself, but probably the written agreement and any bills and anything like that as well. I just don't know if there's current rules that would regulate how many years those need to be maintained or what needs to be maintained.
I thought there was a rule 7 years. When I closed my office back in, I think I called and asked.
There are ethics opinions which talk about it. There's not a rule of professional conduct
Oh,
or a
okay.
statute which says precisely how many years. The default is generally 5 because I think that's the statute of limitations. So to protect lawyers for risk management purposes. But in terms of rule of professional conduct subjecting lawyers to discipline, there's not a hard and fast set number of years.
Probably what I was told. I don't remember.
So again, we're out of time for today, but I just had it on my list of things that we should at least consider. And again, it doesn't necessarily need to be in the rules of professional conduct. Maybe it's a court rule, or maybe it's
Mhm.
statute, or just something if we want to, if there's no rule and we want there to be a rule. It sounds like there's no rule right now.
I just want to comment that this meeting was scheduled till 3:30. Not that we have to go till 3:30, but I just wanted to make sure that everybody knew that.
Oh, thank you.
With regards to Ms. Grijalva's comment, I think we've discussed that before. That was we had a discussion. I brought it up that that's what we see here. But I think what we decided was this legislation is CCP 284 is what I recall, and then 285 is regarding just family law, unilateral subbing out by attorneys is allowed. But isn't that what we decided, that we can't discuss it here, yeah?
Well, I don't know if we decided we can't discuss it here. I think it was not within the scope of what we were deciding for paraprofessional. I mean, you identified, I think, a very, very important issue that hopefully the state bar can put in front of the legislature at some point, because I think that it does inhibit clients' right to terminate representation if they're not able to substitute out their counsel. And it may be something actually that judicial counsel might need to take up at some point.
Mm-hmm.
I don't think there's anything from preventing us from including it in a report as additional changes that are needed, but it's not something that's particular to this paraprofessional program.
Right, so that's what her concern was, that a paraprofessional may not be responsive when a client fires them, so that officially sub out. And we really, I don't remember where we left this off, whether paraprofessionals need to officially sub out when they appear. Do the same rules apply where when there's a paraprofessional making a general appearance in a case, the attorney cannot talk to the client anymore, right? Where are those put out? Pardon my ignorance. Are they part of the rules of professional conduct then?
Well, those are rules of court. So that was not something we were covering in the rules of professional conduct, but that is an issue that we need to decide. And I think I'm not sure if that is part of what Brady is trying to cover in terms of identifying rules of court as well as statutory changes that may be necessary to stand up the program.
Okay. Because I think we should have a discussion, at least decide where it's gonna be discussed.
Mhm. Okay. Well,
Amos, just, sorry, just one more real quick while I have Amos. So our next meeting isn't until the 20th, and right now they're working on those standards. That's what our meeting is going to be about. So I can talk to Leah maybe about between now and that 20th, because it's so far away, having a meeting to talk about those other issues. So I'll talk to her about that.
Or maybe, as you suggest, we could add it to your meeting. If the three of us are available to join on the 20th,
Okay.
that might be the most efficient. So you guys don't have to have an extra meeting. We
Another
could just
meeting.
spend half an hour on it or something like that.
Okay.
Okay. What time on the 20th? Just so I know.
On the 20th, it is at noon.
Okay, well, that's a good idea if you want to send out an invitation.
July 20th?
It's August 20th, actually.
August 20th.
Oh,
sorry.
Yeah, that's
Yeah.
why it's so far out, because they're working on those standards. So I
Got
can't
it.
remember who it is, but there's an attorney from OCTC, right, Greg, that's working on
I
those?
think so, yeah.
Yeah,
Well, maybe what we could do, if we think we'll have time, is one of the upcoming regulation subcommittees and just invite.
oh, that's, yeah.
We have regular meetings. We got to get through these rules first, but I think we should make sure that stays on our radar.
So Greg, what is our next step here for us? I mean, I know we have to talk about how to present these to the group and what to put in it, but then do we go to Brady's memo? Is that where we go next?
I believe so. I'm gonna have to check with Leah because have only been focused on the rules of professional conduct. So I'm not sure. I know she wants to also address proactive regulation with you
That's
all
right.
as well. So we'll have to check in with Leah and see what she wants to, what she thinks should be on the agenda for next week.
All right.
And do we have any action items as members of the subcommittee for next week, or you all gonna come up with the list?
I think we're going to come up with the list, and we're also going to do those rule groupings for the presentation that we talked
Okay.
about.
Okay,
Okay. And I will check on that, the issue that you raised about substitution of counsel with Brady to see if he is covering that in his memo. Okay.
thank you.
All right. All right, everyone. I have nothing else for today. So
Okay,
Thank you.
Thanks,
Thank you.
everybody.
very much.
so much.
Bye, everybody.
Okay. Bye-bye.
Bye, everybody.